Have you ever wondered where you can get a wholesale real estate contract for your next deal? What are the exact contracts you need to close a real estate wholesale deal, and how do you fill them out? What if you put a property under contract but you don't find a cash buyer in time? Are you stuck buying that property? How do you properly back out of that contract? And most importantly, how do wholesalers get paid using these contracts? Well, in this video, I'm going to give you the exact tried and true wholesale contracts that I've used to train thousands of investors to successfully get started in real estate wholesaling. Hey everyone, I'm Ryan Zomorodi, and I'm the co-founder of realestateskills.com, where we help everyday people wholesale and flip houses all across the nation. After being in real estate for over a decade and wholesaling houses in over a dozen states, I can assure you that getting your offer accepted by a seller is often the single most important element in closing a wholesale deal. As I like to say, if you're not making any offers and getting them accepted, you're certainly not closing any deals. And while most people focus on the price and terms, it's also your ability to understand and articulate the contract confidently to a seller, which can make all the difference in getting the seller to commit to accepting your offer. Let's be real for a second. Real estate contracts are very intimidating when you're a new investor and can even cause you to become paralyzed and miss out on amazing opportunities. However, it is vital to think of these wholesale contracts as the money-making tools that they are. Once you understand the basic concepts and get practice filling these out, it's actually pretty easy to fill out wholesale real estate contracts for your deals. These pieces of paper can result in tens of thousands of dollars of profit per deal in your wholesaling and house flipping business when you successfully complete a transaction. These literal sheets of paper and ink govern the transaction between you, the property owner, and your end buyer. Here's what we're going to cover today: how to get your hands on free wholesale real estate contracts now so you can lock up your next deal immediately. It's as simple as clicking the link in the description of this video, entering your information, and downloading them right then and there. You can also go to realestateskills.com/contracts to download them. Be sure to stick around to the end of this video because my goal is to have you leaving with a rock solid understanding of how to use these contracts to secure amazing real estate deals and make money as a wholesaler. These are battle-tested wholesale real estate contracts that you can use to start locking up wholesale deals today. The free download includes both a wholesaler-friendly real estate purchase agreement and the assignment contract. Today, you'll learn how to thoroughly understand and articulate each line of the contract so that you can fill them out and use them in your transactions with confidence. I'm actually going to walk you through the contract line by line and explain each section so that you can use these on your next deal. We'll also cover how to get out of a wholesale contract and how to use this contract to protect yourself from any risks involved in wholesaling. If you don't know the rules of the game, you can't play the game very well. Please take a moment to download these contracts right now so that you can get the most out of this training. I will literally go through each section of this contract, so if you're able to review it and even print them out and fill it out as we go through them, you'll be able to understand these and use them with confidence. Now, before we dive in, you need to know that I'm not a lawyer and I'm not giving legal advice. You alone are responsible for your actions, and you should always consult with a licensed attorney before writing any contracts or performing any transactions in real estate. Contracts do vary from state to state, so it's important to understand your local laws and regulations as you get started in this business. Although it's often misunderstood, wholesaling is such a valuable niche in real estate. Investors are always looking for great opportunities to invest their money, and there are always new deals to be had. Wholesalers are the individuals and companies who specialize in real estate acquisitions. And to be a real estate acquisitions expert, you absolutely must understand wholesale real estate contracts. The two contracts we'll be reviewing today are the most important agreements to successfully wholesale a real estate deal. The first of which is the purchase and sale agreement. This is a written agreement that obligates the seller to sell the property to you according to the contract terms, and so that they cannot sell the property to anybody else. Without a contract, you don't have control over the deal, and the property owner can go ahead and sell it to anybody else. It's also necessary for a title company to open escrow and move the transaction forward. The second contract is the assignment contract. This contract effectively assigns your interest in the purchase agreement to a new buyer who is often a cash buyer. This is what we as wholesalers will charge a premium for in the shape of an assignment fee, because the end buyer will now be able to take over our position in the purchase agreement and get an amazing deal for a 10, 20, 30,000, or sometimes even a six-figure assignment fee that we're able to procure for them. All right, so the first wholesale contract we'll review is the primary contract used in all residential real estate transactions. This is called the purchase and sale agreement, also referred to as the PSA, the purchase contract, the sales contract, or the offer contract, or simply the agreement. Your local realtor contract likely has a different name that you should get familiar with. The purchase and sale agreement is the most important document in a real estate transaction, whether you're going to be wholesaling it, fixing and flipping, or simply acquiring a property for long-term use. There is so much power that comes with thoroughly understanding the purchase contract, no matter what your real estate investment strategy is. When pursuing properties on the MLS, you'll actually have the luxury of working with a professional real estate agent who could provide you with the purchase agreement, write up the contract for you, and present it to the seller. Agents have access to state-specific realtor contracts that can be used for your on-market property acquisitions. However, when you have an opportunity to buy a property directly from the seller, you'll want to use an investor-friendly contract like the one I'm going to give to you today and review in this video. So now I'm going to hop on my computer since we complete our contracts digitally. I'll share my screen so that we can walk through it together step by step. All right, so this is the real estate purchase and sale agreement that we'll use for wholesaling. This is a wholesale friendly agreement, and I'll show you exactly why this is something that you want to use as opposed to other contracts that maybe you found on the internet or that you've otherwise sourced. So the first thing that we'll notice is the notice, which is at the top of the agreement. It just states that this is a legally binding agreement for the purchase and sale of a property, and that if you don't understand this agreement, then go ahead and talk to an attorney. This advises both buyer and seller that, again, if you don't understand it, speak with a licensed attorney about any clauses, and hopefully by the end of this, you will understand every clause in this agreement. And this is just a disclosure that every term in this agreement is subject to negotiation prior to the execution of the agreement. Moving down to section 1, this is where we identify the parties in the agreements. So of course, first and foremost is the seller. Now, this might not just be one seller, okay? There might be multiple sellers of a property, right? Think about husband and wife or business partners, as well as other entities that could be involved. So in this instance, you would write the seller's name, the seller's address, and optionally, you can select the social security number of the seller. And really the purpose of this is to identify the seller. Now, you want to make sure that you've done some title research, speak with a title officer, title company, or look up online to make sure that you understand who truly owns the property in question. Because if you're missing a signature, right, if only one of multiple sellers has signed the contract, then your contract is going to be void. It's not going to be really worth anything because you need all of the sellers to sign. So this is ultra important to make sure you have the correct sellers on this agreement. Now moving down to the buyer. So as a wholesaler, this is where you're going to put your name, whether that's your name as an individual or if you have a business entity, this is where you're going to list your buying entity. So put down the name of your business or you as an individual, as well as your tax ID if you have a business, or your social security number. Again, that is optional. We have that there to make sure all parties are properly identified, as well as the address of you as the buyer. So again, keep in mind that the address in this section is your mailing address, right? Where do the parties reside? Where's your principal residence? This is not the property address of the property that you're going to be purchasing and putting under contract. Now, an important note is right underneath the buyer line. It says, and his, her, or their entity's successors and or assigns. This is language that allows you to seamlessly assign the contract to another entity. So this, in effect, has the seller going under contract with you as the buyer, as well as anyone that succeeds you or that you intend to assign the contract to. Now, you don't have to specify who you're going to be assigning the contract to here. This just makes it that without a doubt, you have the ability to assign the contract. Keep in mind that all real estate contracts are assignable by default. However, this just makes it ultra clear that both parties are agreeing to a potential assignment in the future. And while this rarely does come up in your negotiations, if the seller does ask about it, then your rationale is that you might be assigning this contract, you might be closing in a different entity that you have, right? You might have multiple LLCs. Depending on your exit strategy, you might be converting it to a rental property for long-term use. You might be fixing and flipping this property. Or you might also say that you're bringing in a financial partner to fund this property. So your financial partner might end up closing in the name of their entity in order to put up the funds for this property. This happens all the time and is a very reasonable and sophisticated way to respond and reply to this line in the contract. Now let's move down to the section 2. So this is obviously very important because this is where we're going to identify the real property to be purchased. This is where you're going to identify the property that you're looking to put under contract, the property that the seller owns. So this is where you put the street address, the city or town, the county, state, and zip code of the property. Now in 2C, where it says described as, this is where you're going to put whether the property is a single family property, is it a multifamily, is it a piece of land, as well as the assessor's parcel number, which is also called the property identification number. So in short, it can be the APN or the PIN. Sometimes it's just called the parcel ID. And this is ultimately the tax ID for a property. So every property has a unique identification number that the county assessor's office assigns to it for tax purposes, for identification purposes, for legal reasons. So this is very easy to find by simply going on the MLS, simply going on Redfin or the county tax website and searching for this particular address. And in the public records, you'll easily be able to find the assessor's parcel number or the PIN number for this property. So that's what you're gonna wanna put in section 2C. And once you've completed that, then you're gonna go ahead and move on to section 3. All right, so section 3 is called included in sales price. This just specifies what conveys with the sale of the property. So there are gonna be times when a seller wants to take certain things that are in the property when you are going under contract on it, such as certain appliances, maybe some light fixtures that they splurged on while they lived there, or any personal property that they wanna specify that does not convey with the property. So you'll see that there are items that are specified in here that are included, such as all the electrical, mechanical, and plumbing fixtures, as well as ceiling fans, fire alarms, smoke alarms, the mailbox, pool and spa equipment. So just make sure you review these, and if they don't apply to your property, then they won't really even be applicable. But there is a line that says additional personal property, if any, to be included. So this is where you can specify if there are certain appliances that you want to have conveyed with the property, if there are things such as a chandelier or anything that you want to include with the sale. Maybe there's a nice motorcycle or a car that, hey, maybe the seller doesn't want, but you might find value in, then you can certainly add that here. Sometimes it's something that we can actually help sellers with to say that we're gonna be taking the property that's in the house, such as when we buy a hoarder house, there might be a lot of items that are in the house that we're taking possession of. So you can state that here, again, to really cater to the needs of the seller. Now underneath, there's a line for any leased property. So if there is any leased property that you wanted to add to this agreement, you can go ahead and put that in that line right there. Now moving on to one of the most important sections of this contract, this is where we're gonna state the purchase price. So what you can do here is simply list the purchase price on that first line where it says purchase price and the dollar sign. So that's where you're gonna put the total purchase price. Let's just say it's $200,000. You would go ahead and put it there, as well as underneath all of these other lines where it says total price to be paid must equal purchase price. You'll go ahead and put the price right there. So we would put $200,000 in this scenario. Now, all the lines that are in between those two figures, we're gonna actually break down how that purchase price is going to be paid to the seller. So lines 4A and B are related to the initial deposit that you're gonna be putting into escrow with the submission and acceptance of this contract. So if you're gonna be submitting an initial deposit with the contract at the time that you're submitting the offer to the seller, that's what you would put in 4A. So typically the way I structure my offers and how it's usually done in most markets is that you're gonna submit your deposit when the seller accepts your offer. So that would actually go in 4B. So again, it just depends on what market you're in and some of the customs and traditions in your market. You might submit the deposit with the contract, but most likely you're going to be submitting it at the time that the seller accepts the contract. So you'd put your EMD, as they call it, the earnest money deposit, in 4B. Now in 4C is where you're going to be putting any financing that you're going to be offering with this purchase agreement. So in most cases, if you're a wholesaler using this contract to wholesale real estate, you're not going to put anything in 4C. In some instances, if you're going to use a loan to purchase this property, then you would put the entire loan amount that you're proposing with this offer on the line of 4C. So for instance, if this is a $200,000 property and you were going to get a loan for 50% of the purchase price, then you would put $100,000 in this line. But again, if you're offering all cash, you can leave this line blank. Line 4D is an opportunity to take over the property subject to the seller's existing financing. So if you're looking to do a sub-2 real estate deal, this is where you would list the seller's existing mortgage balance at the time of closing and the time of offer acceptance right here in 4D. So this is a strategy that you can potentially get a very attractive loan in place from the seller and just continue to make the seller's mortgage payments on their behalf once you close on the property. But again, if you're going to be offering all cash, then you do not need to concern yourself with line 4D. Now, line 4E is where you're going to be emphasizing that this is in fact a cash offer. So again, for most wholesalers, you're offering all cash because this is one of the biggest benefits of working with wholesalers and working with investors, is that we can provide the speed and certainty of closing with an all cash offer. So in 4E, this is where we're going to write cash offer, because this serves as a visual emphasis to the seller that this is in fact a cash offer and that they do not have a financing contingency in place. This is by far one of the biggest benefits of working with wholesalers and real estate investors who can offer all cash, because we can provide the speed and certainty that traditional buyers cannot offer when they're offering with a financing contingency in place. So in 4E, this is where you're going to put the balance of the purchase price minus the initial deposit that you might have listed on 4A and B. So for your deposit, you might want to write anything from $100 to $1,000, but generally you want to use 1% of the purchase price to make a competitive initial deposit. So when it comes to your earnest money deposit, it'll favor the buyer to have a smaller earnest money deposit because that means you have less money at risk. For the seller, it makes sense to have a larger earnest money deposit because then that means the buyer is more committed and they have more skin in the game before you even close on the contract. So as long as you're putting at least $1,000 and usually roughly between 1% to 3% as an initial deposit, then you're going to be in good shape and your offer is going to be taken seriously. So if there's any balance that you haven't listed on any of these lines, that's where you would include on 4F, any balance that would need to add up to the purchase price. So ultimately, all of these lines should add up to the full amount of the purchase price. All right, so section 5 is concerning the initial deposits that we covered in section 4 that we just talked about. So if there's an initial deposit due at the time of your contract submission, then that does not go to the seller, okay? That goes to either the listing broker, or more likely it's gonna go to an attorney, a title company, or an escrow company. Now this is super important because we do not wanna be giving money directly to the property owner, right? Directly to the seller. We wanna use a title company or an escrow company to handle all of the money that's being exchanged in this transaction. So this section specifies that the money is not to be handled by the seller. It should be handled by a listing broker or a escrow company, title company, or an attorney. Furthermore, this section also states that if the buyer does not submit their deposit within the time specified above, then the seller has some recourse. They can actually cancel the agreement because the buyer would be considered in default of this agreement. So what happens is that the seller can give the buyer a notice to submit their deposit, and after sending that notice to the buyer, if a period of 3 days pass without the buyer paying that deposit, then the seller may declare the buyer in default and shall have the remedy set forth in paragraph 14. So we'll cover paragraph 14, which is all about buyer's default, later in this video. But keep in mind that the handling of the deposits can vary state by state, so check with a real estate attorney to see how it's appropriately handled in your state. So the next section is the financing contingency, which again, if you're a wholesaler offering all cash, then you can simply cross this section out because this can emphasize that your offer does not have a financing contingency. Again, one of the biggest benefits of working with wholesalers and investors is that we can offer contracts that have very minimal contingencies in place, and the financing contingency is something that can totally ruin a deal for a seller, and it gives a buyer the permission to cancel the agreement if they cannot qualify for the financing specified in this section. So in the case that you did want to include a financing contingency, then you could list the loan amount in 6A, as well as the interest rate that you're offering as part of this contingency. So again, what this means is that if you as the buyer are unable to get the specified loan in this section, and for at least this interest rate, right, if you're quoted a higher interest rate, or you cannot get at least the loan specified here, then this gives you the right to cancel the agreement. So furthermore, you can specify the term of the agreement, right? Most buyers are getting loans that have a 30-year term or a 15-year term. And 6D is also very important, which is called the commitment date. So the commitment date is ultimately when this financing contingency expires. So if you as the buyer cannot get your financing commitment by the date specified in 6D, that means your contingency will expire and you can no longer back out based on this contingency. So in 6E, you can also specify what type of financing you're looking to get. But again, unless you're offering contingent on a loan, then you can simply cross out this section altogether. So underneath the financing terms in section 6, this also states that the buyer's obligation is contingent on a written property appraisal of the property by a licensed appraiser at no less than the purchase price. So this essentially means that if the property doesn't appraise for at least the purchase price, the buyer can terminate the agreement and receive their earnest money deposit back with no problem. This also requires the buyer to apply for the financing immediately after opening escrow and diligently pursue a written mortgage commitment on or before the commitment date. 6F says that if a buyer is unable to obtain a written commitment and notify the seller in writing by 5 p.m. on the commitment date, this agreement shall be null and void and any deposit shall be immediately returned to the buyer. Otherwise, the financing contingencies shall be deemed satisfied and this agreement shall continue in full force and effect. So again, guys, just cross this out if you're making a cash offer. Otherwise, you can use this financing contingency to protect your interest in the contract. Now, section 7 is called condition of premises. This is simply a liability release clause, which states that the buyer has examined the property and that they're satisfied with the physical condition, subject to the inspection contingency if applicable. So again, this is just a liability release clause, and this is not the inspection contingency. This offer is still contingent on the inspection, which we'll cover in the next section. All right, guys, so section 8 is the inspection contingency. As real estate purchasers, as wholesalers, as investors, this is one of the most important clauses that we're gonna wanna have in all of our contracts. It is very rare that we're gonna enter into agreements without having a great inspection contingency, and this one in particular is wholesaler friendly and investor friendly so that you don't risk your earnest money deposit once you're submitting that to escrow and to the title company. So what this allows you to do is inspect the physical condition of the property within a given time frame. So in section 8A, this is when we're actually going to list the deadline to complete our inspections, and this is going to be the deadline for actually having our contingency removed. So 8A just says inspections shall be completed and results reported to seller on or before 5 p.m. on a specified date. So we always recommend having at least 5 to 7 days at a minimum for your inspection contingency. If you can get any longer, then this is only going to benefit you, especially as a wholesaler. So you're going to want to have at least 7 to 14 days if you can. Ideally, you're going to want to have your inspection all the way up until closing. However, it's very unlikely that the seller is going to want to do that for you because you can ultimately back out of the contract if you have an inspection contingency in place. So it benefits the seller to have you waive your inspection contingency altogether, but as a prudent investor, you're probably not going to want to do that unless you're 100% committed to purchasing the property. So the inspection contingency is so important because it not only is an opportunity to inspect the property itself to make sure there aren't any significant defects affecting the value of the property, but as a wholesaler, this is the opportunity for you to get your cash buyers into the property and shop it around so that you can get the highest price and the maximum wholesale fee for your deal. As a wholesaler, you're gonna wanna make sure that you have your buyer walk through the property during the inspection so that in case you can't find a buyer, this is your opportunity to leverage the inspection contingency to terminate the agreement. But our goal is to help you find a buyer for your deal so that you can maximize your profits and make the most money with every contract that you secure. So in order for you to protect your interest as a wholesaler, you're gonna wanna ultimately assign the contract prior to the expiration of your inspection contingency. Otherwise, if your contingency expires, you're gonna be locked in and your earnest money deposit could be at risk. So let's dive into some of this language so that you're ultra clear on exactly what this clause really says. Seller agrees to permit buyer's designees to inspect the real property during the period from seller's acceptance until the date set forth in Section A above. If buyer is not satisfied with the physical condition of the real property and so notify seller in writing prior to the date specified in Section A above, then buyer may, at buyer's option, terminate this agreement. This is super important because it gives you the flexibility as a buyer, as a wholesaler, to say, hey, I am satisfied with the physical condition of this property or not. And so if you're not satisfied for whatever reason, you can terminate this agreement with no questions asked. This is by far one of the biggest protections that you're gonna have as an investor and a wholesaler using these wholesale contracts. Buyer may give seller the option to correct the conditions that are unsatisfactory to the buyer. Should buyer elect to terminate this agreement or seller is unwilling to correct any unsatisfactory conditions, the buyer shall notify seller on or before 5 p.m. on a given date of buyer's election to terminate this agreement, and if terminated, this agreement shall be null and void, and any deposit monies paid hereunder shall be returned immediately to buyer, and neither buyer nor seller shall have any claims against each other under the terms of this agreement. If buyer fails to notify seller as provided herein, this contingency shall be deemed satisfied and this agreement shall continue in full force and effect. So guys, this is important to know that you must notify the seller of your decision to either terminate the agreement, of your decision to move forward, subject to all of the things that you found during your inspection, or you can give the seller the opportunity to correct any deficiencies that you've identified that you've requested in your notice. So the second date on this contract is really concerning your ability to elect to terminate the agreement or your ask for the seller to correct any deficiencies. So as investors, we typically use this as an opportunity to either back out of the agreement if this deal is a complete no-go, if for whatever reason it's a deal that we do not want to pursue. Maybe we just couldn't find a buyer that wants the deal. Maybe we locked it up at too high of a price. But if we wanted to terminate, then this is the opportunity to tell the seller in writing that we're out, that we want to back out, and that we'll get our earnest money completely refunded at this point. So as a pro tip, you can use this as the perfect opportunity to potentially renegotiate the purchase price. So during your inspection, you might discover things that were not disclosed to you by the seller upfront when you formed the contract and entered into this agreement. For example, there might be things like a foundation issue or a structural issue that maybe even the seller didn't know about. So when you discover these things during your inspection, you can bring them to the surface and use this as the basis for a potential price reduction. If the price of the property doesn't work for your cash buyers, when they walk the property and give you feedback, you can now ask them what price works for you and what price can you commit to. You can use that price and go back to the seller and use that as the foundation for a price reduction so that you can renegotiate a price that works for your wholesale fee and also works for your buyer to move forward and ultimately close on the property. So it's very important to keep in mind that if you do not notify the seller of your intention to move forward and remove the contingency or terminate the agreement by the date that you specify in the contract, then your contingency will expire. So make sure you take note of this date because you must act accordingly or else your initial deposit, your earnest money deposit could be non-refundable at this point. Now 8C is where you would initial if you wanted to waive your inspection contingency entirely. So you would not have the protections that we just talked about in the inspection contingency. So I wouldn't recommend anybody do this unless you're 100% committed to purchasing this property or your cash buyer is 100% committed to doing this deal. If you initial 8C, then that means you would not have any inspection contingency. You would not have the right to inspect the property and potentially renegotiate based on your findings in the deal. So this is particularly risky if you have not actually been inside of the property or if the seller hasn't given you a ton of information about what's in the home. When you enter a contract, a lot of times it's surface level and you don't have the opportunity to thoroughly look at the property itself. And honestly, most of your cash buyers are gonna wanna set eyes on the property and do their own walkthrough. A lot of new investors ask us, do I need to actually hire a home inspector to go out and inspect the home during my inspection? So as a wholesaler, we recommend that you actually don't get a property inspection during this time in the contract. Get your cash buyers to walk through the property themselves, and based on their walkthrough, they'll give you the green light on whether they want to move forward with the deal or if they're out and you just need to find a different buyer for the deal. All right, so moving on to section 9, this is just a standard disclosure that you're gonna see in pretty much every single real estate contract. This just states that properties built prior to 1978 may have lead-based paint, which simply is a disclosure for public health that is required to be in every single contract. So there's nothing you need to do here. Just be aware that it's a standard disclosure that is included in almost every single purchase agreement. Now, section 10 is titled Occupancy, Possession, and Closing Date. This is simply stating when the closing date for this transaction will be. Now, I would recommend putting at least a 14-day closing period from when you enter into this contract to when you desire to close. It will serve you better to have a longer closing date so that you can have more of an opportunity to find the perfect cash buyer for your deal so you can maximize profits on this contract. Especially if you're going to be fixing and flipping and raising private money to buy, fix, and sell this deal, then you might want a longer closing date in order to raise the appropriate funds and close on this property. So usually we offer a 14-day closing date because that makes us more competitive versus other finance offers that might need 30 to 45 days, so we can give these sellers the speed and convenience of working with a cash offer that can close in a matter of weeks. This clause also gives the buyer the right to do a walkthrough inspection within 48 hours of the closing date because you want to make sure that the property is in the same condition as when you entered into the contract to when you actually close on the property. This ensures that any poor weather conditions or any mishandling of the condition of the property can be addressed prior to you actually closing and funding the deal. So your cash buyers are definitely going to appreciate having that in there. Finally, this is an opportunity to specify what title company or escrow company that you want to handle this transaction with. We recommend using an investor-friendly title company, a wholesale-friendly title company, especially if you're going to be double closing on the property. However, if you're not sure what title and escrow company you want to use, then you can simply insert in this line buyer's choice. So then that gives you the opportunity and the right to choose and designate a title company after you go under contract. We've had many wholesale deals where our buyers prefer to use their title company that they typically work with. So if you put buyer's choice here, then that gives you the flexibility to work with a title company that your cash buyer ultimately prefers to work with. Now, section 11 is warranty deed. Now, this simply just states that the title of the property is going to be conveyed using what's called a warranty deed. There are many different types of deeds that you can use to transfer ownership of the property. So there's not much you need to know here other than that the warranty deed is one of the most favorable types of deeds that you can receive as the buyer of a piece of real estate. There are other types of deeds such as a quitclaim deed and a grant deed, but we certainly do not want a quitclaim deed because that means that the property could come with different liens and we don't guarantee that there's a clean and clear title to the property. So just keep this in mind that we're going to get a clean and clear title to the property, otherwise we can terminate the agreement. So section 12 actually specifically states that the seller is guaranteeing that we're going to receive a clean and clear marketable title upon closing. So this is very important because this requires the seller to deliver the property with no liens, such as a loan that is still outstanding. Maybe there's some back taxes, some utilities that have been unpaid, as well as maybe some mechanical liens, some mechanics liens on the property that they're agreeing to pay off and settle before the property officially transfers title. So it's important to note that this section actually acts as another contingency, which I call the title contingency, because if the seller cannot deliver marketable title to the buyer, then the buyer has the right to back out of the contract and receive their earnest money deposit back without any question. So this is always important to have in there because when we're working with distressed sellers, sometimes they have back taxes and liens that maybe they're not even aware of. So when you do your title search, when you're working with a title company or an attorney, they're going to be able to make sure that the title is transferred to you without any clouds or encumbrances, or really just any problems with title that the new buyer is going to inherit. All right, so section 13 is all about the prorations and adjustments. So this section simply just covers any prorated expenses and income that would be due to both parties at closing. So in many states, these adjustments will include taxes, water and sewer charges, estimated insurance payments, and other similar adjustments. So keep in mind that these might vary state to state. So refer to your local contract and refer to your local title company to make sure that these are being handled appropriately. So don't worry, the title company, the escrow company, they're gonna make sure that all of these expenses are paid down to the dollar by the seller, and that you're only responsible, or your cash buyer is only responsible for the expenses on the day that they close and beyond. Also, if you're taking over a tenant-occupied property, the buyer is gonna be entitled to the rent from the day that they took ownership and beyond, and the seller is only gonna keep the rent for the time that they own the property. A lot of times properties close in the middle of the month, so this really applies to when they need to prorate these expenses and the income. As well as the security deposits, we want to make sure that those transfer to the new buyer, because the new buyer is going to be liable to pay the tenants once the tenants move out. So this is just important to protect all parties and make sure that these expenses and income are handled in a fair fashion. So there's nothing you really need to do here. Just know that this is in here to protect both parties. All right, now section 14 is buyer's default. This is something I referred to earlier in the training. And this is important for every real estate purchaser to thoroughly understand, because this protects your downside risk. No matter what contract you're using, you should be looking for the buyer's default clause in the contract. So ultimately, this states the buyer's rights and consequences if they're unable to hold their end of the agreement. So I'll actually just read this because it's so important to understand. It states, if the buyer fails to comply with any terms of this agreement by the time set forth for compliance and seller is not in default, seller shall be entitled to all initial and additional deposit funds provided for in section 4, whether or not buyer has paid the same as liquidated damages, and both parties shall be relieved of further liability under this agreement. If legal action is brought to enforce any provision of this agreement, the prevailing party shall be entitled to reasonable attorney's fees. So something that's really important to note is the term liquidated damages. This is an important term that you want to have in this section of any contract you use, because ultimately what this means is that the financial consequence of a buyer's default is limited to the earnest money deposit that has been stated earlier in the contract. So again, in other words, let's say you put $1,000 as your deposit in the contract, then if you default on the contract, right? If you cancel the contract and you're not under your contingencies, then the legal liability, the financial consequence for the buyer is limited to that $1,000 earnest money deposit. Otherwise, the seller could go after you and pursue legal action really with an unlimited ceiling. So having a liquidated damages clause is super important, and that's why we've included it in this particular contract. So not only is this enforceable if you don't submit your deposit, really any other term provided by this contract will be related to his buyer's default. So ultimately what that means, if you as the buyer don't actually fulfill your end of the agreement, no matter what the term is, then this could apply and you're technically in default of the contract. So keep in mind that any earnest money deposit, you want to make sure you're acting while you're under your contingencies to make sure you're not in default. So for example, if you are not within your inspection contingency, right? If you removed it altogether and then you don't close on the property, then it is very likely you could be in default of the contract, and then the seller's recourse is keeping your earnest money deposit. So it's very important to understand what's the downside risk, right? What happens if you default on your contract as a wholesaler? Because this clause will then determine what's the potential consequence for you as a buyer. So understanding this allows you to move forward with confidence, knowing that there is a limit to your liability as the buyer, as a party to this contract. So again, get very comfortable, no matter what contract you're using for wholesaling, get comfortable with the buyer's default, because then this gives you the confidence to move forward and really understand what your risk is in this deal. Now, moving forward to section 15, this is titled Risk of Loss Damage. So ultimately, this protects you as the buyer, as the wholesaler, in case there's any particular damage that happens to the property while you're under contract with the seller. For example, if there's poor weather that results in a flood or some serious damage to the property while you're under contract, this gives you, as the buyer, the right to terminate the agreement and walk away and receive your earnest money deposit back, even if you've removed your inspection contingency. So this really does serve as another contingency. And further, this also gives you the right to move forward to purchase the property in the case that there is a loss or any kind of damage, because the seller may have an insurance policy which you as the buyer can take the proceeds and actually apply that to the property or just put it in your pocket. So this clause in particular protects you in a number of ways, which is why this contract is very advantageous for you as a wholesaler. So again, if there is a loss and there is an insurance claim, then you might be able to receive a significant sum of money to cover those damages. So you might actually decide to move forward even if there is a flood or even if there is a fire while you're under contract. So in other words, this clause essentially protects you as the buyer, and it protects your interest in case there's damage to the property while you're under contract. It also grants you the option to exercise your right to purchase the property in the event of a fire or if other significant damage happens while you're under contract, and receive the insurance proceeds for such damage, which may even be a better option for you. So essentially, this clause protects you as a wholesaler, and most certainly it protects your buyer, because if something happens to the property while you're in escrow, this gives them the right to terminate the contract and get the earnest money deposit back, or move forward with the property and receive any insurance money that might be paid as a result of an insurance claim. So this can save the deal if anything happens to the property while you're in escrow, which is why it's very important to have a clause like this in your wholesale contract. All right, so moving on, paragraph 16 is just a common interest community disclosure. So if you're buying a condo or a property that's in an HOA, this is just a simple disclosure that's very broad that can apply really to any state. So this just says that the seller will comply and deliver the resale documents in accordance with local statutes and customs. There's nothing you need to do here. Paragraph 17 is regarding the listing broker. So if there is an agent who's listed this property, this is an opportunity to state them, to acknowledge them, and also check the box if it is a dual agent, meaning if the listing agent is representing both the seller and the buyer on this transaction. It's very important to disclose this in real estate contracts. There's a lot of licensing laws and there's a lot of rules and regulations about disclosure if a broker is representing both parties in a deal. So there's also a place to state the cooperating broker, which in other words is the agent or broker who's representing the buyer in the transaction. Again, if you're not working with the real estate agent on this deal, then you can simply leave this blank or just cross it out. Paragraph 18 is mandatory seller disclosures. Now, these can vary from state to state. Every state has their own customs and local laws and requirements around what the seller is required to disclose to the buyer during escrow before the sale is finalized. So this clause just simply states that the seller shall deliver to the buyer within the time specified by local statute all disclosures as required by law in the state where the property resides. If the seller fails to deliver such documents in the time specified above, the buyer reserves the right to all remedies available to buyer under applicable law. So as you get acquainted with real estate in your market, you'll begin to understand what are the common disclosures that sellers are required to submit during escrow before a transaction's finalized. So this clause protects you, and just make sure that the seller knows and is aware that they are required to provide mandatory disclosures before closing. Section 19 is equal housing rights. This simply states that the agreement is subject to all local statutory laws prohibiting discrimination in commercial and residential real estate transactions. That's pretty self-explanatory. There's a lot of laws federally that protect real estate transactions from discrimination, so you can look those up. It's just a blanket statement, so there's nothing you need to do there. Section 20 is where you can list any addenda and advisories that you'd like to make a party to this agreement, which you'd want to attach to the purchase agreement. For example, if you're buying a property with tenants in place, you're going to want to include an addendum that states all of the rents and security deposits that are applicable for each unit of the property that you're putting under contract. Also, if this is a short sale or a trust sale, anything beyond the usual, then this is an opportunity to list any additional addendum or advisories that you want to make a party to this agreement. All right, so section 21 is additional terms and conditions. This is a great section to have in any real estate wholesale contract because it allows you to add terms to the contract that are unique to the particular sale and the seller's situation. So for example, when we're working with distressed sellers, motivated sellers, there might be different terms that allow them to feel comfortable selling to us that we want to include in our contracts. For example, if they want some money to help with their move, or if they want us to take possession of some of their personal items, then this is the opportunity where we can state them and make them part of the contract so that everybody is comfortable and on the same page. So keep in mind that this section is here to allow you to have some flexibility with the terms to make sure the sale is a win-win for everybody involved. So 22 is email or fax transmission. This is simply an acknowledgement from all parties that states that anything that is submitted over fax or email is intended to be fully binding and in full effect. So anything that's communicated over these means, just keep in mind that it will be binding and the parties are agreeing to this. 23 is complete agreement. This is something that you'll see in a lot of real estate purchase agreements that simply says this is the entire agreement between the buyer and seller concerning this transaction, and it supersedes any and all previous written or oral agreements concerning the property. If there's any extensions or modifications of this agreement, then it shall be in writing and signed by all of the parties in order to be considered a part of this agreement. So 24 simply states that any notice that's required or permitted under the terms of this agreement shall be in writing, as well as addressed to the party using that address that we included in paragraph 1 of the agreement when we identified the parties to the agreement. Or we could also send it to the party's attorney or the listing broker that we stated previously in the agreement. So anything that needs to be communicated, any notices under this agreement, such as the notice to submit the deposit that we talked about earlier, that must be in writing. And this is simply an agreement which states such. Now, paragraph 25 is extremely important to have in your wholesale real estate contract. Whether you're going to be wholesaling the deal or even if you're buying it for a rental, this is a very important clause that you're going to want to make sure is in your contract. So I'll go ahead and read it to emphasize. So 25, disclosures and contract provisions. Seller acknowledges that the buyer has the right to market the property and or contractual interest in the property in any way before closing. Seller understands upon signing this agreement that buyer will possess a contractual interest in the property. So why would you want to market the property or your contractual interest in the property, right? That's often what we do as wholesalers. So this is how we can find a buyer. We prefer to have our buyers ahead of time, but a lot of wholesalers will be going out and looking for their buyers after it's under contract. Furthermore, if you're going to be renting this property, then you want to reserve the right to market the home for rent on different websites. And if you're going to be marketing the contract as well online, this just makes sure that the seller agrees to and is fully disclosed that you may be marketing and advertising the contract or the property once you're on contract, even before you close. Section 26 is regarding short sales. So in the cases of a short sale, this just states that the parties shall work together to work towards the short sale. So the bank or lender or any lien holders agree to hold sellers or named persons on title as of this agreement, harmless of any further actions, and will not hold seller accountable for the remainder amounts owed. So it really just shows good faith from you as the buyer. It shows that you're going to be working to make this short sale happen. There's a lot of work that's required. And it also has the seller agree to comply with any work that's necessary in order to perform a short sale. So if it's not a short sale that you're pursuing, then you don't have to worry about it. If it is a short sale, then this is an important clause to show good faith and also cooperation from both parties. 27 is the license acknowledgement. So again, when there's realtors, licensed agents involved in a transaction, they must disclose that they're a licensed agent. So this easily allows license holders, whether they're the buyer or the seller, to disclose that they're a licensed realtor and disclose the state that they're licensed in. So if you're not a licensed realtor, you can simply ignore this section, but if you are a licensed agent, then you can simply check the box and write the state where you're licensed in. And that will satisfy the licensing disclosure for the contract. 28 is a simple acknowledgement from both buyer and seller that they have the power and ability to enter this agreement, that they have both read and understand this agreement and voluntarily accept the duties and obligations set forth herein. It also states that the buyer shall deliver a copy of this agreement to the seller within 7 days. Now, 29 is time to accept. It says that the seller shall have until a given date to accept this agreement. So you can leave this section blank if you want to just have your offer out there, and whenever the seller signs this agreement, that's when the effective date will start. However, if the seller needs some time to make a decision, if they need to talk to their partner or their attorney, and they're kind of leaving you open-ended, then you may want to put a deadline in this contract for them to accept your offer. So you might want to give them 24, 48, or maybe 72 hours before this offer expires. That way it puts a little bit of pressure on them to know that, hey, maybe you're buying multiple houses and you need to know whether the seller is committed to doing this deal with you or not. So it's really your choice if you want to put a timeline. We'll generally give them about 3 days in order to make a decision and sign on the dotted line. And of course, you can always resubmit your contract. So this is a way to ensure that the seller is respectful of your time, but keep in mind that you'll always have an opportunity to resubmit the contract if needed. And finally, section 30 is where you'll want to get signatures from all sellers involved. Whoever's on the parties line for the sellers, if there's multiple sellers, you want to get all the signatures, and this is extremely important. And of course, you'll sign as well and put the date. And keep in mind that there are initials boxes on every single page. So you'll want to make sure that you as the buyer, as well as all of the sellers, are signing here in section 30, as well as initialing on every single page in the appropriate box. So congratulations, we made it through the purchase and sale agreement. Once you've completed it and filled out all of the sections, then you can go ahead and send it to the seller for them to sign. Keep in mind that the seller is not going to be filling this out for you. You're going to want to fill it out completely and then send it to the seller and make sure you get all of their signatures. Once you have their signatures, then that means you have a legally binding agreement, and then you can move on to the next stage of your wholesale real estate deal. So the second contract that we're going to be reviewing today is the assignment contract. This is what you're going to be using once you have a fully executed purchase agreement, because that is going to effectively allow you to transfer your interest as the buyer in the purchase and sale agreement to a different end buyer. We refer to these as cash buyers, financial partners. This is ultimately the person who's going to take over your position in the purchase and sale agreement and fulfill all the obligations, funding, and closing on this wholesale property. Fortunately, the assignment contract is a one-page, simple document that I'll be able to explain to you in a very short amount of time. Keep in mind that this assignment contract is available for download. Just click the link in the description and you can download it in a matter of moments, or go to realestateskills.com/contracts to get your copy right now. The assignment contract is between you and your cash buyer. The seller of the property is not going to be named on this particular assignment contract. So once you have a motivated, committed cash buyer for your wholesale deal, you'll go ahead and send this assignment contract to them to sign and approve, and then you'll take that contract and send it to the title company for them to arrange the transaction to close with your cash buyer. So I'll share my screen on my computer so we can fill this out and walk through it together. Here is the assignment addendum that you have access to in our wholesale real estate contract download. So starting at the top, I'll just read through it so you thoroughly understand it, because this is such an important document. This is really how we get paid as wholesalers. This assignment addendum assignment is between assignor, which is going to be you as the wholesaler, the buyer on the original contract, and assignee, which is your cash buyer. So again, you are the assignor as the wholesaler, the buyer on the original contract, and the assignee is your cash buyer who's going to be receiving the assignment. The assignor and assignee, which mentioned together, may be referred to as parties. On the given day of the given month on a given year, the assignor entered into a purchase agreement with the sellers and the assignor as buyers for rights to purchase the property located at property address, in the city of city, in the state of state. So this is simply where you would put the effective date of the contract, which oftentimes there's a date specified on the top, on the first page of the contract. However, if there's not, like in our contract, then you would simply put the date where the last signature was obtained. Typically, this is when the seller signs your agreement. So whatever date that the seller signs and you have a fully executed purchase and sale agreement, that is the date that you will put down on this assignment addendum. Now, of course, you'll just want to list the sellers, of course, the same parties that are on the purchase agreement here, as well as the property, the address is here. You can also put that assessor's parcel number here if you just wanted to be sure of it, but normally what's given here is sufficient. A copy of the agreement has been attached and can be furnished upon request. So of course, you're going to want to send the purchase and sale agreement to your cash buyer so that they can review it as well. They can get comfortable with the terms that you have agreed to with the seller. Assignor wishes to sell his, her, their rights and interests in the purchase agreement, and the assignee wishes to buy all of the assignor's rights and interest and accepts receiving title and interest in the property. In exchange, the assignee agrees to be responsible for and paying the assigner an assignment fee of, and here's where you insert your wholesale fee, right? So if you want to put $5,000, $10,000, $20,000, $30,000, whatever you negotiate on this deal, this is where you're going to put the total assignment fee for your deal. And that shall be paid on or before the closing or settlement date. If the assignment fee is paid at closing and through escrow, this fee shall be made out to the assignor on the HUD settlement statement. So I recommend, guys, get your fees paid through escrow, through title, so that you're on the settlement statement. And especially if you're a new wholesaler and you don't have a track record of doing deals, this is one way that you can demonstrate to lenders and partners that you in fact are doing deals when you are on the settlement statements as a wholesaler. So furthermore, the assignee agrees to pay a non-refundable deposit to the assigner due at the execution of this assignment of X amount of dollars, which is refundable only if the title is not clear and conveyable. So this is an opportunity to insert a non-refundable deposit to your cash buyer. So especially if this is a new cash buyer relationship, you may want to ask for a non-refundable deposit for the privilege of receiving the assignment of contract from you. So this is an opportunity to reimburse yourself for the earnest money deposit. If you have submitted that to escrow for the seller, this is a way that you can get reimbursed there. And a pro tip is you can ask for a larger deposit from your cash buyer than what you've submitted to escrow to the seller, so that even if your buyer does not close, you can still earn a wholesale profit. So sometimes you might put 0 here if you don't want to charge a non-refundable deposit. That's okay too. In instances where you have not put up the earnest money deposit yet, then you might put a 0 here and just require that your cash buyer funds the EMD on your behalf once they receive the assignment of the purchase agreement. And keep in mind that this non-refundable deposit would actually be refundable if the seller cannot perform and if they can't convey clean and clear title to the end buyer. And also, this non-refundable deposit is a credit towards the assignment fee. So for example, if you're charging a $20,000 assignment fee as stated in the first section, and your non-refundable deposit is $5,000, then the total assignment fee is still $20,000. So they would simply pay you $5,000 at the time of the assignment of contract, and then the rest would be due at closing. So they would pay you $15,000 once the transaction closes. Furthermore, this assignment of contract is not effective until the deposit is paid and both parties sign this assignment addendum. So I really like this clause in particular because it allows us to make the cash buyer committed financially to doing this deal and not just take over the assignment without any risk on their end. So this assignment is only effective if both parties sign the assignment of contract and the cash buyer funds this non-refundable deposit to you. So this non-refundable deposit can be sent directly to you as the wholesaler, which is something that I prefer, or it can be paid to the title company. If they pay directly to the title company, make sure that the title company has this agreement and that they know what this money is for so that it can be sent to you in the case that the buyer doesn't end up following through with the contract. So finally, some additional terms and conditions which are extremely important. So this says the parties agree to the following terms and conditions. Number 1, assignee is agreeing to all terms, clauses, and conditions of the purchase agreement, and by executing this assignment below is agreeing to be liable for any and all of assignor's obligations and liabilities in the purchase agreement. Further, assignee hereby agrees to indemnify and hold assigner harmless from any claims, fees, expenses, costs, demands, liabilities, or obligations related to this assignment, the purchase agreement, and the property. So in essence, this is having the cash buyer agree to anything that's in the original purchase agreement, as well as hold the wholesaler harmless for any potential liability that might occur for taking over the purchase agreement. Number 2, assignee hereby agrees to close on the property per the purchase agreement on or before, and here's where you list the closing date. If assignee does not close by this date, assignor shall have the right in their sole discretion to terminate this agreement, assign the purchase agreement to a third party, purchase the property, and take legal action against assignee for any and all damages or liability this causes. Further, assignee agrees to forfeit the deposit to assignor. Should assignor fail to act timely and take the above actions, the parties agree that assignor retains and is not waiving said rights and interest. So in essence, this gives you as the wholesaler protection in case the cash buyer doesn't actually perform on the purchase agreement, so that you can take back the purchase contract and reassign it to another cash buyer, and it gives you the right to even pursue damages from the other party who didn't close on the contract. So in the case that the seller pursues damages from you as the wholesaler, then you can actually pursue the buyer because they're ultimately liable according to this agreement. This also has the cash buyer agree that if they do not perform on the purchase agreement, that you as the wholesaler have the right to keep their non-refundable deposit without any question. And finally, number 3, assignee has reviewed the purchase agreement and assignee fully understands the terms and conditions of this assignment addendum. So just an acknowledgement that they've read the purchase agreement, they've read the assignment addendum, and that they fully understand the terms and conditions. And finally, you have your signature section where you'll want to put both parties' full name or business names, their signature, as well as the date that this was signed. Once you have that, congratulations, you have a fully executed assignment contract for your wholesale deal. After you have a fully executed assignment contract, go ahead and send a copy to your attorney, the title company, or your escrow company so that they can start moving the transaction forward to close with your end buyer. All you need to do at this point is make sure that everybody is on the same page and make sure that your buyer is fulfilling their end of the deal, and simply just stay in touch with them, stay in touch with the title company, and just make sure that if anyone needs anything, you're there to help facilitate the closing of this transaction. And finally, our favorite part of this deal is on closing date, you will receive a check or a wire from title with your assignment fee as stated in the assignment contract. And congratulations, that's one of the most exciting parts of wholesale real estate, is when you get paid as a wholesaler. So you'll be well rewarded for all your efforts in going through these contracts, negotiating with the seller, putting this deal together, and then providing an amazing opportunity for your cash buyer to slide right in and close and ultimately fix and flip, buy and hold for a rental, or really whatever they'd like to do with their new investment. So there you have it, guys. I hope this video has given you a rock solid understanding of how to use wholesale real estate contracts and that you're able to use them with confidence. Remember to download the wholesale contract templates that I covered in this video by clicking the link in the description or going to realestateskills.com/contracts. Keep them handy so that you can act with speed and certainty the next time you come across an opportunity to wholesale a property. You never know when that next deal is going to come up. If you have any questions whatsoever, go ahead and ask them in the comments of this video. Thank you again for watching and learning about wholesale contracts. We'll see you in the next video.